Hi, everyone. This is Jackie Bain with the Florida Healthcare Law Firm, and we're just really excited to be presenting to the Medical Association. And over the course of the next few weeks, you'll get one of everybody, I think, from my law firm, the Florida Healthcare Law Firm, and hopefully we can have a little bit of fun tonight. That being said, my obligation here is to talk about how HIPAA has been impacted by the COVID-19 pandemic. So, it's not the most exciting topic, but certainly necessary given what we do. Just so you know, I've saved a copy of the slides under handouts, so you should be able to access those. Let's get started. Okay, so HIPAA is the Health Insurance Portability and Accountability Act. I always start my HIPAA presentations by saying, please change your mindset when it comes to HIPAA. HIPAA is a process for safe and appropriate disclosure of medical records. It is not a privilege to hide behind. So when people say things like, I can't because of HIPAA, that's not necessarily true. I think about it this way: I'm not authorized to under HIPAA, not that I can't, because HIPAA is really thinking about ways in a way towards disclosure and not towards protection. Because we're going to be using a few words pretty consistently throughout this presentation. The first word is covered entity, or I guess term is covered entity, and that includes health plans, healthcare clearinghouses, and healthcare providers that transmit information electronically. If you are on paper records, then you are not a covered entity, but hopefully everybody who's listening to this is on electronic records by this point. And then every covered entity generally has business associates that help it achieve its mission. And business associates are persons or entities that perform certain functions on behalf of covered entities and whose work involves the use or disclosure of PHI. PHI we'll define in a minute, but generally it's your outside billing companies, outside records reviewers, people who really help the operations of a covered entity and help it kind of be better at what it's doing. If you do have business associates, and most covered entities do, you have to have a contract in place with them in order to ensure that they'll safeguard and protect the PHI that it has access to as part of your covered entity. Just so everyone is aware, these contracts, if they're really old, should be updated because in 2013, the obligations of business associates changed. So if you have an old business associate agreement in place prior to 2013, you should turn it around and maybe put a new one in place. And just another thought for those business associates out there, you want to make sure that you actually read your business associate agreement, because a lot of times business associate agreements say things like, we're going to adhere to all of the covered entities' privacy policies and procedures. And if you don't know what those are, you don't have access to them, it's really hard for you to abide by all of them. So generally, if you're going to agree to that, then you need to have access to those policies and procedures to make sure that you're doing everything right. A lot of times business associates will have their own business associate agreement that they give to covered entities, and that's fine too. But these are not the kind of pro forma agreements that people think they are, that are just kind of attached as examples on or exhibits to contracts. These agreements are negotiated a lot, and you want to make sure that you have every right that you have to have under those agreements in place. And then the last term that we're going to be using a lot tonight is PHI, which is an acronym for Protected Health Information. And PHI is really any personal identifying information that either individually or combined with any other identifying information that could identify a specific individual or their past, present, or future health care or their method of payment. PHI is created by covered entities. And this is something that is super important. If it wasn't created by a covered entity, it's not PHI. PHI does not include information that is contained in education records or information that is maintained by healthcare organizations in their capacity as employer. So for instance, if a hospital, as part of your personnel file, has that you requested a maternity leave, in the past, then that maternity leave request is not considered protected health information, even if you delivered at the hospital, because it's maintained in your employment file. Underneath the third bullet, I've listed all 18 identifiers, which are the examples of PHI that the federal government has put out. This is not an exhaustive list. If there's something that's not on this list that is also able to identify a person, that would also be considered PHI. Okay, so HIPAA has 4 rules: the privacy rule, the security rule, the breach notification rule, and the enforcement rule. And we're just going to run through these really quickly. So the privacy rule establishes standards to protect individuals' medical records and PHI, protected health information. It applies to healthcare providers that conduct certain healthcare transactions electronically. These transactions are also defined by the statute, and it's something that people just generally gloss over. But if you have the time and the wherewithal to make it through a super boring statute, I really think you should Google the standard transactions of HIPAA to make sure that you actually are a covered entity under HIPAA. Because if you're not doing what these standard transactions are, then you're not considered a covered entity and therefore not subject to HIPAA. The privacy rule sets limitations and conditions on the uses and disclosures that may be made of PHI without patient authorization, and we'll get into those. The security rule establishes national standards to protect electronic PHI that is created, received, used, or maintained by a covered entity on behalf of its patients. The security rule requires appropriate administrative, physical, and technical safeguards in place to ensure the confidentiality, integrity, and security of electronic PHI. Here's a for instance. An email that is transmitted by a covered entity to a business associate must be sent via end-to-end encryption. So if you have a something going on where you're sending emails that are not encrypted or secure, as part of, and those emails include PHI, you are outside the bounds of the security rule. Under the security rule, the covered entity is required to ensure the confidentiality, integrity, and availability of all electronic PHI it creates, receives, maintains, or transmits. And the covered entity is responsible to identify and protect against reasonably anticipated threats to secure the integrity of the information. So this is your risk assessment. As a covered entity, you should be performing on a regular basis, generally annually. Although we do understand that in the last year or so, you guys have been dealing with a lot. So if you haven't had one done in 2020, I think the time is right for you to go and obtain one in 2021. Either your IT provider can help you do that, or there are plenty of outside companies that can help you do a risk assessment in order to identify places where you might need a little bit more protection. There's hackers and just generally bad guys out there on the internet all the time, trying to not only gain access to the information, but in a lot of cases hold that information ransom so that you have to pay in order to get it back. So you just want to make sure that you're doing everything right. The covered entity is required to protect against reasonably anticipated impermissible uses or disclosures and ensure compliance by its workforce. This means that you're educating your workforce on hire and at least annually about their obligations under HIPAA. And again, there are tons and tons of resources out there on the internet that can help you do that if it's something that seems overwhelming to you internally. The breach notification rule just says that basically following a breach, the covered entity is required to notify all affected individuals within 60 days of discovery or when it should have been discovered. And if you can't get in touch with 10 or more people, then you have to do something called substitute notification. And that means you either have to put a banner across your website, which is really good for business, or even better for business, alert the news media in the area where the breach occurred. So if it was a national breach, that means you're alerting national news media. And then every covered entity within has to notify HHS of every single breach that happens. So this means that you fax the medical records to the wrong fax number and it winds up going to a McDonald's somewhere. That's a potential breach that needs to be identified and noted to the Secretary of HHS. It's a really easy form. It's right on the HHS website. If you have less than 500 records that are affected, you have to do it within 60 days after the end of the year. And if it's more than 500 records, that's a lot of faxing, just kidding. But if it's more than 500 records, then you need to do it within 60 days of discovery. Something that's super important here is that you recognize that this is a federal law and that states generally have their own privacy laws for protection of their medical information or just general confidential information. California has a new one that's very, very broad. Florida has its own. So even though you might have 60 days under HIPAA, state laws may allow only for 30 days or 45 days. So you just certainly have to know your obligations under those laws as well. And then last is the enforcement rule. The enforcement rule contains provisions relating to compliance and investigations and the imposition of civil monetary penalties for violations and procedures for hearings. OCR enforces HIPAA. OCR is the Office for Civil Rights. It's a division of the Federal Office for Health and Human Services, Health and Human Services Department. But anyway, OCR is the the government body that's tasked with enforcing HIPAA, and it enforces it in several ways. One, it investigates complaints that are filed with it. If somebody believes that their information has been shared and it shouldn't have been, they can just log on to the website and make a complaint. Likewise, if you have a competitor that maybe you don't have, the best relationship with, again, they could make a complaint about you. OCR is tasked with enforcing those complaints. It can also conduct compliance reviews to determine if healthcare providers are in compliance with the law. And this is something that happened a lot, maybe 3 or 4 years ago. OCR really kind of battened down the hatches on the relationships between covered entities and their business associates, ensuring that the policies and procedures that are required of each were in place and that the contracts that are required were in place. They would just randomly send out letters to covered entities saying, send us all the information about your business associates. And then they followed that up a few months later with letters to all of the business associates saying, send us the information about your covered entities. So they do this. It is something that is not that pleasant when it's happening to you, but it certainly doesn't mean that there's anything wrong from the get-go. And then, of course, last is they perform education and outreach to foster compliance with HIPAA. When HIPAA first came out, it was first announced in 1996. They started to issue regulations for it in 2000. They didn't do a lot of enforcement for a long time, but now they do lots and lots and lots of enforcement because it's been almost 20 years. I'm doing the math in my head, more than 20 years. And it's been on the books for a long time, so it should be a part of your general processes. And it's something that you should have integrated into your practice by now. So they are enforcing it, and they are enforcing it in a lot of ways. So when they're enforcing something, they review the level of culpability of the entity that had the breach, whether it be a covered entity or a business associate. And new in 2019, we have these fancy tiers that are really focused on the culpability of the breach. Tier 1 is the kind of least, it's for not big breaches, I guess is the way to say it. I mean, I guess a breach is big to everybody it happens to, but this is for the not big ones. So it goes from $100 to $50,000 per violation, and it's capped at $25,000 per year. That's your fine. The entity in this case might have been ignorant, and potentially with due diligence might not have even known about a potential violation. This includes your kind of brute force attack hackers and things like that, where you had everything in place, but they got through anyway. You could be issued a fine depending on the breach. Tier 2 is $1,000 to $50,000 per violation, capped at $100,000 per year. And again, this violation is the next kind of up the scale of seriousness. The violation could have happened even with safeguards in place, and the individual should have known about the violation before it occurred. So maybe something that was identified on a risk assessment, but maybe hadn't been handled yet. Tier 3 is $10,000 to $50,000 per violation, capped at $250,000 per year. And in this case, the entity was willfully negligent, but corrected the violation in a timely fashion. This is where Tier 3 comes in. So this is something that probably where a lot of the breaches fall in, where you either didn't do your risk assessment, but you responded once you realized that there had been a breach, or something like that. And then Tier 4 are kind of the bad boys. These are the ones who are willfully negligent and made no attempt to correct the violation. And in this case, they may have even tried to cover up the violation, which is where the biggest fines fall. Tier 4 is $50,000 per violation, capped at $1.5 million per year the issue existed. So if you say all of a sudden, whoopsie, realize that one of your internal facing servers has been facing outward since 2018, we're looking at 3 years and a cap of $4.5 million on your entity. So, and $50,000 per violation. So it's a big deal. And this is why it's so important to keep your HIPAA policies and procedures not only up to date, but also just in general, heed them and know that they're there going forward. So during COVID, a lot changed, and it's changed temporarily, and it will go back to what it once was, at least the law will. As we know, the healthcare itself has probably changed forever, in that generally there's been a trend towards use of telehealth hugely during COVID-19, the pandemic. And generally there's been a lot more expansion in the technologies that are being used in order to facilitate healthcare to people who are either sick or homebound or anything like that. So it's not necessarily all bad, but it's certainly been an expansion in orders of magnitude faster than it would have been expanded had there not been COVID-19. So there are 4 ways that OCR has said that during COVID-19, it won't hold covered entities or business associates responsible because they were just trying to do their jobs in an absolutely unprecedented time. The first one that came out is OCR guidance was issued actually in April, but it was retroactive to March, about community-based testing sites for COVID. This still exists to this day, and all 4 of these enforcement discretion guidelines that have been issued are still in place, and they will be in place until the Secretary of Health and Human Services says that we are no longer under an emergency, a national pandemic. So I think it'll probably be big news when that happens. So I don't think you'll need a whole lot of guidance at that point. But at that point, when the secretary says, we don't, we're going back to the way things were, what he means is that the enforcement discretion, the leniency that they've been affording to people to, quote, almost not comply with HIPAA during this time will be gone, and you've got to go back to what it was before. Meaning that your technologies all have to be compliant, your policies and procedures have to be up to date. You've got to do your risk assessments regularly. You've got to educate your people regularly, and you need to go back to doing the way things have always been done, at least for the past 25 years. So the first one is for community-based testing sites. I think this is probably one of the biggest adjustments that, say, someone in my lifetime has had to make, which is to kind of walk up to a window and have somebody lean out the window and swipe your nose. There certainly isn't any privacy involved in that encounter, and you certainly are not afforded the privacy that you would have in any other testing site ever before, or ever since HIPAA came into play, I guess. So basically, certain covered entities or their business associates may choose to participate in the operation of specimen collection and testing sites, which includes mobile, drive-through, or walk-up sites that only provide COVID-19 specimen collection or testing services to the public. So what that means is, if they're not providing it to the public, then this does not apply. And if they're doing anything else but COVID-19 specimen collection, then this does not apply. If you are walking up to a site and it's a COVID site and you're going to be tested and they say, hey, we can do some genetic testing for you too here, you want to make sure that that you're doing everything right at that point, because you're now outside this discretionary services that have been put out. The second is for business associate disclosures. This started in April of 2019, and it continues to the present. Covered entities and their business associates are not subject to penalties for violations of certain provisions of HIPAA for uses and disclosures of PHI by business associates only for public health and health oversight activities during the national pandemic emergency. So this means that if something happens outside, if a disclosure happens that's not for the purposes of public health or health oversight, you're outside the bounds of this discretionary enforcement. You can have HIPAA enforced against you. The last time I checked, the enforcement amounts in the last 12 months were on par with what they had been for the 12 months prior to that. So OCR has not stopped enforcing HIPAA. There are just certain things that they're giving leniency for, and this is one of them. And this is different, I guess, this is a little wonky on my part, but this is different, I guess, from regulations prior to this enforcement discretion guidance, because PHI could only be disclosed by a business associate for public health or health oversight activities if it was expressly permitted by the required business associate agreement. So now, even if the business associate agreement is silent, you can do that. The business associate can do that. Third, and probably the largest discretionary guidance that's been given began in March, and that's for provision of telehealth services. Certain covered entities or their business associates may seek to communicate with patients and provide telehealth services through remote communications technologies that may not be fully compliant with the requirements of the HIPAA rules. One thing I always used to preach about before HIPAA is that FaceTime is not compliant. Doctors should not be FaceTiming with their patients in order to conduct health screenings or anything like that. Well, during COVID, this is no longer the case. Covered healthcare providers can use any non-public facing remote communication product that's available to communicate with patients. So even though it might not be the most secure communication, it is certainly something that you can use while the pandemic is in play. Again, once the pandemic is declared over by the Secretary of Health and Human Services, this enforcement discretion goes away, and you've got to go back to having a compliant means of communication. Next is scheduling vaccination appointments. This just began in December of 2020, and it's certain covered entities or their business associates may choose to use online or web-based scheduling applications for the limited purpose of scheduling individual appointments for the COVID-19 vaccination. Even if it wouldn't otherwise be HIPAA compliant, this is something that can be done. And the purpose for this, I'm sure we can all remember the mad rush that happened earlier this year, is to quickly schedule large numbers of individuals for appointments for COVID-19 vaccination during the emergency. Again, this is for COVID vaccinations only. So any other vaccination, any other scheduling, all has to be done through a HIPAA compliant means of communication. Okay, so when does HIPAA apply to a vaccination status? This is something that I see on the news, just in general, out in public a lot. A patient's vaccination status is considered PHI or protected under HIPAA when it is maintained by a covered entity or its business associate. Note the word patient there. A patient's vaccination status is PHI, not anyone's. just the patient at issue. HIPAA regulates how and when a covered entity or its business associate uses or discloses information about a patient's vaccination status. Again, key word there, patient. HIPAA prohibits a covered entity and its business associate from using or disclosing a patient's personal health information, including information about whether the patient has received a vaccine or the patient's medical history or demographic information. There are exceptions to this. 1, the covered entity or business associate can use or disclose this information with the patient's authorization. Obviously, if the patient says it's okay in writing, then that's fine. 2, as permitted by HIPAA. And 3, as required by HIPAA. So what's permitted by HIPAA? When can a covered entity disclose a patient's vaccination status without having the patient's authorization? When are they permitted to do that? The first is to treat the patient's health, the disclosure can be made to the patient's health plan to obtain payment for administering the vaccine. 2, to a public health authority. 3, to the patient himself or herself or themselves. 4, when required to do so by law. 5, when the permitted disclosure can be made to the patient's employer to evaluate whether the patient has a work-related illness. This is for workers' compensation patients. And last, to the patient's employer to conduct an evaluation relating to medical surveillance of the workplace. And that means the spread of COVID within the workplace. These are the permitted disclosures that you can make a patient's vaccination status or a patient's PHI generally known. HIPAA does not prohibit any person from asking whether an individual has received a particular vaccine, including the COVID-19 vaccines. This includes covered entities and business associates. There is nothing stopping me from asking you if you've received the vaccine. I am not a covered entity, so there is nothing stopping that. HIPAA does not prohibit an individual from choosing to provide any person or entity with information regarding his, her, or their vaccination status. I can tell you if I'm vaccinated or not. HIPAA doesn't protect that. Again, I'm not a covered entity, nor are most people who are saying that they can't do things because of HIPAA right now. And last, HIPAA does not regulate the ability of covered entities and business associates to request information from patients or visitors. There's nothing stopping your doctor's office from asking if a patient is vaccinated. It is a simple question. The patient can disclose or not disclose, but there's nothing stopping you from asking. All right, so when does HIPAA not apply? HIPAA does not apply when when an individual is asked about their vaccination status by a school, employer, store, restaurant, entertainment venue, or any other individual. Even if the employer is a covered entity, say a hospital, they can ask whether or not a workforce member is vaccinated. HIPAA does not apply when an individual, their doctor, or when an individual asks another individual, their doctor or a service provider, whether or not they're vaccinated. So if I go to the doctor tomorrow and ask her if she's vaccinated, that's okay. It's up to her if she wants to answer, but there's nothing illegal or outside of HIPAA associated with me asking the question. And HIPAA does not apply when an individual asks a company, such as a healthcare provider, whether its workforce members are vaccinated. If I'm seeking a pediatrician for my child and I call and say, hey, I'd like to establish as a new patient there, is your workforce vaccinated? There's nothing stopping me from doing that. Again, there's the people on the other end of the line have every right to answer or not to answer, but they certainly can be asked the question. So if your people sitting at your front desk are answering the phones, they should be coached as how to answer that question if it's asked. It could be a resounding yes. It could be a we believe in individual rights situation. But we certainly, especially given the political nature of this this pandemic that we're in, there should be some coaching happening at the front desk and anybody who's dealing with the public as to how to respond to these kinds of questions. Because again, HIPAA is not stopping you from answering those questions. HIPAA does not prohibit an employer from requiring a workforce member to disclose whether or not they've received the vaccine to the employer, clients, or other parties. Therefore, like for instance, if a physician comes into my office to speak with me and asks me if I'm vaccinated, and my employer tells me I have to tell them whether or not I'm vaccinated, then I've got to tell them. Again, my employer is not a covered entity, so there's no reason why I shouldn't be able to say whether or not I'm vaccinated. HIPAA does not regulate what information can be requested from employees as part of the terms and conditions of their employment. So if you walk into your doctor's office tomorrow where you're employed, and the office manager says, hey, we need to know whether or not you're vaccinated, HIPAA doesn't protect you there. So if the terms and conditions of your employment are you've got to be vaccinated to stay here, then they can certainly request that information from you. HIPAA does not apply to employment records, including employment records held by covered entities and business associates acting in their capacity as employers. So again, a hospital acts as an employer. It's also a covered entity, but when it's acting as an employer, it's not considered a covered entity. So if they're asking questions for you for your personnel file, then it certainly doesn't create any PHI at that point. PHI is generally created when a physician or other healthcare provider produces information based on an interaction with the patient. If they ask you to bring in your vaccination card, then there's nothing being produced by a healthcare provider at that point, and therefore HIPAA doesn't really apply. That's really how you should consider it. If it wasn't produced by a physician, it's not really covered by HIPAA. Or if it wasn't produced as part of your payment information, whether through your health plan or clearinghouse, then it's not really covered by HIPAA. A couple more questions. Vaccinations in the workplace. HIPAA does not prohibit a covered entity, or in this case, we'll say a doctor's office or any healthcare provider, lab, pharmacy, anything, from requesting or requiring each member of the workforce to provide documentation of their COVID-19 or flu vaccination to their current or prospective employer. A lot of hospitals and healthcare providers have been requiring flu vaccines for a very, very long time. So it should come as no news to those who are working there that proof of vaccination status for any other contagious disease or should also be kind of contained in the same vaccination policy as the flu policy. One thing I will say is to make sure that your policies are even-handed across the board. If you are requiring proof of vaccine for flu, then you should use the same policy as you're using for COVID-19 because it doesn't make any sense to do something special when you already have a process in place. One thing that I really adhere to a lot is to say that there's really no reason why anybody should reinvent the wheel here. If you've already got a good process in place, then use it. If you don't have a good process in place, then put a good process in place and you can use it across the board. Okay, HIPAA does not prohibit a covered entity or business associate from requesting each workforce member to sign a HIPAA authorization for the healthcare provider to disclose the workforce member's COVID-19 vaccination to their employer. I pulled this information directly off of the OCR's website, so it's not really up for debate. based on HIPAA. And then HIPAA does not prohibit a covered entity or business associate from requiring workforce members to wear a mask while in the employer's facility, on the employer's property, or in the normal course of performing their duties at another location. Again, if you say own a home health agency, there's nothing stopping you from requiring that your workforce wears a mask while the patients are being tended to in their own homes, so that there's a protection there for the patients, and you need to make sure that that all discipline is applied even-handedly. If you've got one person who's not wearing a mask and not getting in trouble for it, then there really isn't any reason to just discipline another person for not wearing a mask. Again, the discipline needs to be applied even-handedly and across the board. And you should always have a policy to fall back on. So if you're requiring masks while around anyone, that's the policy. If you're requiring masks around patients, that's the policy. No ifs, ands, or buts about it. So people know exactly where the line is drawn. And then HIPAA does not prohibit a healthcare provider from requesting that or requiring that each workforce member disclose whether or not they've received the COVID vaccine in response to a patient's inquiries. So if a patient asks you if you have had your vaccine and your employer's policy is you answer the question honestly, then you answer the question honestly. Again, this is just kind of things that that there should be a policy in place about at this point. It's been well over a year now. All right, we only have a couple more slides left. So I've said all of this, and a lot of people ask, but we live in Florida, and so there's the executive order and a law that really protect us from all of the what you've said earlier. And let me give you just a little bit of background on that. On April 2nd of this year, Governor DeSantis issued an executive order prohibiting businesses in Florida from requiring patrons or customers to provide any documentation certifying a COVID-19 vaccination or post-transmission recovery to gain access to, entry upon, or service from the business. This means that if I was walking into my local coffee shop without a mask on, they can no longer tell me that I have to wear a mask. July 1, 2021, the Florida legislature had passed and Governor DeSantis signed into law Statute 381.00316, and that applies the prohibition to all business entities and applies a fine of up to $5,000 per violation. So really here, what this means is that if I do walk into my local coffee shop and they request that require that I put on a mask, well, they have to require it. They can request it, they don't have to require it. If they require that I put on a mask and I make a complaint about it, they could have a $5,000 fine levied upon them for violating this new law. However, the law allows businesses, however, to require employees, vendors, or independent contractors to be vaccinated to provide COVID-19 vaccination documentation. The law doesn't say anything about the workforce. All it talks about is the consumers, the public that comes into your place of business to receive your services. So, there really is, it's really silent on whether or not employers can allow or require employees, vendors, or independent contractors to wear masks while in the business. So if it's the policy of the business to wear a mask while you're working, that's the policy of the business, and it does not violate the law. And then the law does allow businesses to institute screening protocols consistent with authoritative or controlling government issued guidance to protect public health. If they wanted to screen you upon entry to a building, they can certainly do that. And honestly, they do. If you go to a large venue, they'll likely screen you upon entry. They were for a very long time taking temperatures when you walk through the door places and things like that. As long as there is authoritative and controlling government issued guidance to justify what you're doing, then you're fine to continue doing it. And most notably, this law does not apply to healthcare providers. So going back, requiring patrons or customers to provide documentation certifying vaccination to gain access to or entry upon the business, that's something that a healthcare provider can certainly do. I'm not sure, I think a lot of them are still doing it. I know hospitals are still doing it to ensure that you are COVID negative before you enter their population in order to protect, of course, the public. So that's really what I've got for you tonight about how COVID has affected HIPAA in the last 18 months or so. I think generally there will be a certain letting up at some point in the near future on some things. A lot of the state executive orders in all of the states really has started to expire. So I don't expect that, especially the enforcement discretion under HIPAA, to last in perpetuity. I do think that it's something that will come to an end within the next year or so. So you just want to make sure you're ready. A lot of people have been relying on HIPAA, the enforcement discretion, in order to conduct telehealth over non-secure websites and things like that. I think it's probably time to get your secure website in place if you haven't already, in order to ensure that once the pandemic is declared either under control or over by the Secretary of Health and Human Services, that you are compliant as soon as that switch is flipped. It's been a pleasure to give this information to you guys tonight. My contact information is up on the screen. If you have any questions at all, please feel free to reach out. I will look forward to seeing you guys next Thursday. As I mentioned earlier, some of my colleagues will be helping out over the next couple of weeks in this series. So have a great night, and thanks so much for joining us.